Okay, members. Let's move to the next item. The relevant papers are at 251 to 396 of your meeting folder. Can I formally welcome Alan Hunter, Chief Executive, Mr. Peter O'Brien, Assistant Secretary, Ms. Catherine Dixon, Past President, and last but by no means least, Mr. Michael Robinson, President of the Law Society, and you're very welcome to the meeting. Again, this will be recorded by Hansard and it will be published in due course. And if you're content then, let's move on and I'll hand over to yourself.
Thank you, Chairman. The Law Society would like to thank the Committee of Justice for the opportunity to present to you today on the issues in relation to levels of representation in civil and family proceedings, and we're particularly grateful that you're hearing us now after such obviously a complicated and busy afternoon. Thank you very much for bearing with us on that. At the outset, may I take this opportunity to outline for the Committee the Society's basic position in relation to securing access to justice for all in our society. The key principle for us when it comes to securing the rights of the most vulnerable sections of society is that of appropriate representation in each case. That means, Mr. Chairman, an appropriate team of skilled professionals providing a quality service for adequate remuneration. The fundamental importance of the issues involved demands this. This vulnerability can come at the hands of state agencies or large commercial organisations in the civil justice system, whether by serious injuries or other forms of unfair treatment. It is our firm view, Mr. Chairman, that the Department has not set out a case for making the proposed changes. The absence of any analysis of the sources of cost drivers in the civil justice system undermines attempts to simply abstract one issue, that of legal representation, and turn it into a problem. In relation to one of the larger categories of family law, namely children order cases, it is the law, Mr. Chairman, which places the child at the centre of this process, and if this is to change, it must come through parliamentary mechanisms. Until such a time, we have a duty to ensure that vulnerable children are effectively represented in the manner which the legislature requires. It is up to the Department to make the case for reform before the debate over the real issues can begin, and we do not believe that this has yet been done. I should take this time to note, Mr. Chairman, that we are here today to specifically discuss the representation issue, although we appreciate it is linked to wider issues around fees and costs, which we would be happy to discuss at a later date. If one looks, for instance, at children order proceedings, the welfare of at-risk children is absolutely paramount, and you've been discussing that this afternoon. Not only do we strive to protect the safety and human rights of those children, but by doing so, we also ensure that a principle of early intervention and protection reduces pressure on the justice system further downstream. What you're deciding when you consider the question about representation is what value you place on the needs of vulnerable children in our society, and you ought not to lose sight of that. Indeed, the consequences of broken families and vulnerable children extend beyond the justice system into education and pressures on caring institutions and services, and so we ought not to assume that cutting costs is a simple equation of fees and representation with no focus whatsoever on value. Much has been said in relation to the increasing volume of children order proceedings in recent years, but in many respects this is the outworking of a more accountable society. People no longer feel compelled to view mistreatment of a child as something that is not their business or is outside the scope of public interest. Chairman, we should be thankful that we live in a society in which the most vulnerable have every chance of escaping their difficult circumstances, and affording them access to appropriate legal representation is the most effective way to secure this undoubted imperative. The only way to ensure that justice will prevail is to accord each party to proceedings an equality of appropriate representation, and to ensure that no one is disadvantaged for want of financial means. That, Chairman, is in keeping with the spirit of the legal aid scheme when it was first introduced in the Second World War, in a context in which it was felt that access to justice was the glue that would hold society together, strengthening the weak, affording equality to all, and providing an essential building block of an emerging welfare state and stable society. This strain on the social compact is evident from a close look at the relevant figures. According to statistics produced by the DHSSPS, referrals to children's services increased in 2010-2011 by 18% from 2005 to 2006 and 9% on 2009 to 2010. Similarly, between 2006 and 2011, there was a 46% increase in the number of children on the Child Protection Register. Between 2011 and 2012, there was a 3% increase in the number of referrals concerning children in need. Although some improvement in the numbers of children on the Child Protection Register during the same period is observed, overall there is an upward volatility in the figures in recent years. In such a scenario, the overriding concern ought to be to ensure that the interests of these children are protected with vigour and zeal. Like so many aspects of public welfare, there is an inverse relationship with economic security and general well-being in the population. That is unfortunate due to the accompanying fiscal pressures, but that is the reality of what we must all now face. Equally, given the increasing public scrutiny in relation to the care of and contact with children, it is of considerable importance that the ability to reunite families is preserved in order to advance the common good. The greater the difficulties in relation to abuse and the significant challenges facing frontline care workers in making assessments of welfare, the more important it is for worthy parents to be enabled to make their case also when they need to. When the Children Order was introduced in 1995, these levels of representation were agreed by Parliament as being of the appropriate level and standard to secure the best interests of vulnerable children in keeping with our domestic and international obligations. It must be emphasised that this was not a scheme designed for lawyers by lawyers, but by the legislature for the protection of the vulnerable under the order. I feel that it is important to set out clearly and to ensure that the debate is properly focused on what is the appropriate level of representation to protect the human rights of vulnerable people. This is an imperative made more pressing by the introduction of the Human Rights Act in 1998. The emphasis on the protection of the child as a central tenet of a civilised society has increased with the introduction of the Children's Charter in 1889 and most notably with the UN Convention of Human Rights. This is an area in which we as a country are rightly proud and want to lead. The key issue is the level and skill of commitment being applied to securing these rights. And Chairman and members, I am pleased to say that in Catherine Dixon, I have an example of that skill and commitment. Catherine is a very experienced practitioner in children's order cases and knows intimately the difficult social issues involved in such litigation. Catherine reflects the fact that advocacy is a growing and skilled discipline for solicitors, and as a society we would stress the ability of our members to undertake work on behalf of clients in a wide range of civil and family proceedings. It is not the label applied to the practitioner which matters, but the level of specialisation that the relevant practitioner can bring to bear on the appropriate proceedings, which is the key. We are keen to emphasise that in the majority of proceedings in question, solicitors are taking full carriage of the case, such as the 92% of cases under the Children Northern Ireland Order 1995, which conclude in the Family Proceedings Court, and a large number in the Family Care Centre, which accounts for a further 3% of the recorded cases. Provision for counsel is only necessary in a small percentage of overall cases, and the increasing specialisation of solicitors and solicitor advocates has reduced this number to a particularly complex and specialised area of advice. We must stress, however, that in our view many of the proposals in the consultation are insufficiently flexible to ensure appropriate representation in all appropriate cases. Firstly, it must be stressed that there is not a perfect correlation between court tier and the complexity of the legal and factual issues involved, and that simply stripping out the possibility of counsel in line with court tier is a blunt measure which focuses on a narrow view of cost cutting rather than identifying appropriate representation. This is particularly so in the context where overall pressures are to keep cases out of the High Court and to do business more effectively by disposing of cases in the lower courts. In our consultation responses, we noted, for example, the potential for more complex cases to remain in the Family Proceedings Court under the terms of Article 5.1 of the Children Allocation of Proceedings Order 1996. This issue is thus neither the court tier nor the title of the practitioner undertaking the work, but the fact that different type of works may arise across all court tiers and may require more than one practitioner being involved. It is a fact that just as more complex surgery requires more than one surgeon to perform it, more complex cases require the skills and expertise of more than one practitioner to progress them. Allowance for such provision does not make it the norm. Neither does it open the floodgates to avoidable costs. It seeks to serve the interests of justice in a small number of appropriate cases. Therefore, as solicitors continue to increase in their specialisation, the level of work that they will undertake will naturally increase, provided there is a proportionate relationship between remuneration and work undertaken. This latter point concerns the importance of a solicitor balancing advocacy functions with managing a small business with multiple employees and client care issues. If we want to streamline the system and increase the proportion of work carried out being undertaken by solicitors, we must put in place appropriate remuneration to ensure that these services can be provided in a cost-effective manner, to ensure that solicitors can meet their essential costs and continue to act as responsible employers in the community. Whilst we appreciate that there is a real need for efficiency savings, as an organisation we are critical of the impulse to seek to reduce costs through stripping out representation in advance of an all-encompassing review of how the civil and family law system is currently operating. Indeed, one part of this picture that hasn't been mentioned in the consultation is the fact that fees under discussion haven't actually been increased by the legislature since 1996 when they were originally set. Similarly, we would emphasise that the number of cases in which multiple parties make applications for legally aided representation is limited by judicial direction to circumstances in which this is necessary because of competing interests in the particular case. To extrapolate this and to seek to portray this as a significant cost driver is clearly and palpably misleading. We make these statements in keeping with the general principle that cost-saving reforms are often interdependent and conditional upon taking a system-wide view generally. Policy making in a fragmented, ad hoc manner risks public money in the long run by introducing the possibility of avoidable, if unintended, consequences. This view is not to preserve the Law Society or practitioners generally. In our consultation response at page 5, we identified that access to justice review considered the blanket removal of discretion as a risky move, which would have implications for effective legal representation. That access to justice review recognised the holistic nature of the justice system. One cannot make an assessment of the function of one organ without reference to its interaction with others. The Society has made representation on a number of occasions to the effect that effective forecasting of expenditure is a problem which should call into question the adequacy of the overall legal aid budget. The continuing emergence of funding pressures creates a situation in which it might be perceived that costs are suddenly rocketing year on year, when in fact an analysis of that reveals that a planned budget would have provided a better reflection of social need at the earliest stage and opportunity. We are not here to discuss the wider financial picture today, Chairman, but it suffices to make the point that taking certain areas in isolation is apt for a misdiagnosis of the problem holistically. The Society has spoken of the possibility for interim payments and progress forecasting as one mechanism to adequately control expenditure, along with the importance of IT and processing systems. It's a bit like a patient going for a check-up where a doctor only examines one area of the body. All organs of the civil and family justice system need to be examined to deliver effective and proper and long-lasting reform. At this point in time, it is difficult to determine with any confidence from this consultation paper that the Department has an overall view of what they would like the family and civil justice system to look like. If one were to undertake such an evaluation, an analysis of court cost pressures, system-wide delays and the identification of areas of inefficiency would precede any consideration of proposals to reduce the level of service. The lack of a fundamental review, with the last review on delay carried out by children order practitioners themselves in 2003, calls into question the evidence base of suggested reforms. The Society has maintained in response to this consultation paper that we support complete transparency and the setting of appropriate criteria to ensure that levels of representation match the complexity of the issues. Our concern is that what is being proposed is not proper filtering, but effectively a blanket removal of representation without due regard to the interests of everybody involved in the process. Our concern is that insufficient regard is being shown for the intentions of Parliament when providing for these important rights, and that this wrongly animates the current proposals as they stand. In summary, the Society considers the single most important principle in civil and family justice to be appropriate representation in appropriate circumstances. Access to justice and network of community legal representatives is our core belief, and that remains constant. We are seeing changes in the outworking of that in the civil and family arena, as solicitors assume more work in accordance with increasing specialisation and experience. But provision for additional specialist representation is also an aspect of that principle in certain limited circumstances. The present consultation takes an overly rigid view of the respective roles of each branch of the profession, focusing on cost without the other side of the coin, which is value. The Department appeared to be working on the presumption that by stripping out the provision for additional legal advice in exceptional cases, core costs will be reduced without any detrimental effect on the service provided to those who badly and desperately need it. We suggest, Chairman, that this is a grave error and is an avoidable one. The position of the Law Society is that the most vulnerable sections of our society should be entitled to the representation they require to access the justice that they deserve in appropriate cases. We regard this as a fundamental principle of the welfare state and one that cannot be sacrificed without significant damage to social fabric. The Solicitors branch of the profession is committed to working with the Department of Justice to reduce avoidable costs and delay within the system, and we recognise that these demands are more pressing than before. It is our feeling that the Department is missing a wider opportunity to achieve these objectives without harming access to justice in the process. We are here today to urge them to think again. Mr. Chairman, that concludes our presentation. I offer my representatives for questions. Thank you for the opportunity to speak.
Thank you very much, Mr. Elliott.
Chair, thank you and thanks for the presentation. Declaring that this first chair has been on the Northern Ireland Board of Adoption UK. You did say there, Michael, that there is no proper filtering, I think is the word you used. Do you believe that the system could be improved if there was better filtering and that would cut out some of the fat in the system?
Filtering in terms of the choice of counsel?
That's what I'm assuming you meant.
And lawyer. We're saying that we put proposals in under the review, and we have already said this in the previous review that in cases of this type, you just do not get counsel. If counsel or a second or third lawyer in the case, whatever name they have, are just not given to you. You have to apply to the judge and make a case for the appropriate representation. There are proposals with regard to that filtering process at that stage and how that filtering will be defined. we say that filtering and the suggested definitions of that filtering are far too narrow. But there is in the system currently a filtering process. I think there's some question as to whether that process should be filtered more tightly and more tightly defined. We say that it's entirely appropriate to have a filtering process, entirely appropriate to decide what cases deserve what level of representation. We say that it should be appropriate representation in appropriate cases, having appropriately determined in accordance with properly decided criteria what that filtering should be. But maybe some of my colleagues could elucidate more directly on the filtering criteria for you.
They're all looking at me, so it must be me. As a practitioner, what happens is when the case comes in, I look at the case and I try to work out, is this something I feel comfortable in managing myself, or do I think I need additional expertise, and then I determine what to do. And if I require additional expertise, the way it's currently structured is that expertise would be a barrister, but that may not be the case in the future. Currently, I would apply to legal aid and ask for authority for counsel. Now, I haven't actually, throughout my entire career, I think if you could count on fingers of one hand the number of counsel I've instructed in the Family Proceedings Court. I've always run my own cases at that level. I run most of my own cases in the Family Care Centre. Occasionally, there's technical points, things that need drafted, things that I can't. It's not cost effective for me to do it. So it's about managing the work in relation to what you're actually doing. So each case you look at as you go along. One of the things I worry about is that there's this assumption that the case is the same for everybody. But you may on occasions, I would extensively represent children instructed by specialist guardians, specialist social workers. So my position's different than that of some of the other representatives, because clearly some of them are acting for very vulnerable mothers who may have all sorts of problems, some of the things that you were talking about before, prostitution and drugs and all sorts of issues. Dealing for someone working as a client, having that sort of person as a client is a different thing. I'm often being instructed by a specialist social worker for a young child. So I might see the child once because I like to see my client, even if they're only wee, but I do like to have seen them because I'd be the only lawyer in the courtroom who has seen the child. So I will go out, see the child. After that, all my instructions are with a fellow professional. So I don't always need, we're able to work as a team and work out ways of working things. If you're working with parents, you're working with a different kettle of fish, because often they are very vulnerable. Many of them are products of the care system themselves. So we've already failed them once. Not to give them proper representation now is to fail them yet again. So that's when you have to decide who do you need and at what level you need it.
Chair, thanks for that. On the issue of cooperation with social workers in particular, as they're the other professionals I'm assuming that you would have quite a lot of contact with, how good is that relationship and cooperation, and if that were to be improved, would that actually help? Because what I'm looking at in the consultation is clearly a financial saving is what the department's looking for, essentially. Let's be blunt about it. Could it be improved if there was better cooperation, or do you feel that there is a really good level of cooperation with social services? Well,
I think maybe you need to think about where the case is coming from, because in the child protection cases, the cases are being brought in effect by the social workers through obviously the mechanisms that exist for them to be represented. On a personal level and in courts generally, I find you can approach social workers at any time. Now, I'd always check with their solicitor that it's okay to speak to them, but as a general rule I can lift the phone and talk to them about any particular point. And if I see the need that, what about if we got Mrs. Jones brought in the taxi to see the specialist who's going to decide whether she's got a mental health problem or not that prevents her from parenting her child, then I'll ask the social workers, would you lay on a taxi so at least we guarantee she gets there? So there are all sorts of things. Those things happen quite a bit already. The pressures on the system are really immense. I mean, in the last number of years, the number of cases we have has increased quite significantly, and the complexity of the cases are being dealt at a lower level. So what's happened is it's a pyramid system with more and more cases. So what would have been 10 years ago considered a High Court case is not going to the High Court. And in some cases, even now, it's being managed in the family proceedings courts because the pressure is to keep only the worst cases, only the very worst cases go to the top. And that's as it should be. But as it's become more complex and as it's clearly more cases, the more complex cases are getting pushed further down. So what we're dealing with now, we wouldn't have dealt with in the family proceedings court 10 years ago. So I think there isn't that is part of why we're saying the system needs looked at properly, because it's creaking. It's absolutely creaking. When you go to court, you can see the pressure and the time frames, the length of time the cases are taking to get dealt with is extended, because there's only so much that can be done in a day or a given day that the courts are available to do. And if we're going to do things properly, then, and within the current structure, it just can't all continue the way it is at the minute. And it's not just legal aid, it's social work. It's social work teams aren't all fully manned. I mean, there's many of the teams I'm dealing with, there isn't 6 in the team when there should be, so there isn't always the people to cover things. So it really is, this is only the tip of a problem. The whole problem is much bigger than just taking out some representation. It's the appropriate representation at each level that's important. I wouldn't want to run a High Court case on my own. It's as simple as that. Occasions I have had to, by necessity, run bits of High Court cases on my own. I wouldn't want to do that as a general basis. I couldn't service the client properly doing that.
Just in relation to your point, Mr. Elliott, there have been steps taken over the last number of years, in fact, to bring in sort of various guides to how these cases are dealt with and how they're managed. And that happens both on the public law side, where the state intervenes to bring children into care, but also more recently now in respect of private law disputes between parents with regard to contact and residence. And certainly those steps that have been introduced, there's now a pre-proceedings stage, which is an attempt to see whether or not at a much earlier stage, before things get as serious as the issue of court proceedings, where there would be engagement between the families and lawyers and the social workers for the various trusts, where there's an exchange of information, where reports are given. We've had the benefit now of a sort of standardised reporting system of how these cases use the Cheney, which you may have referred to the committee at times before, so that there's a standard way where these are all recorded. That evidence is shared, and there are pre-proceedings cases before cases get, where there are attempts made to narrow the issues where records are kept. Catherine possibly has the benefit of direct experience at some years since I myself was in practice, and these have been introduced more recently, but they are opportunities for liaison between the legal representatives of the parents generally in these cases and the social workers who are dealing with this in the first instance on the ground, and for the sort of people that Catherine is referring to are the very specialist guardian ad litem service, who are there specifically as social workers, looking generally all of social work background, but who are looking specifically after the interests of the child.
Just to sum up here very quickly, you're saying that while a filtering system, a better filtering system, will actually improve and maybe reduce the finances better, but without overall reform, which would include the social service net, you're not going to make any real significant difference. Is that reasonable?
That's absolutely right, and we say also that let me emphasise at the start as a lawyer that in this system that we don't write our own cheque for these cases. Someone has to grant the authority for counsel or for a second or third lawyer in the case, and I think it's often misunderstood, and we read it in the papers about how bad we are and we're all just going out and writing cheques. We're not doing it. Someone has decided that it's time that on an appropriate application that a second or third lawyer should be involved in the case. Those decisions are made judicially. They're made on appropriate applications following appropriate criteria. We say that to bring in drivers where you simply decide that all of X type of serious cases are moved down to one particular court, and that's why we're saying the tier doesn't matter. The tier is some indicator of the seriousness of the case, but it's not the only indicator. And simply to force everything down into the middle tier and then to say in that tier you're going to have X number of lawyers, is not the answer. You need to look at each of these cases and to have the flexibility to decide that in any particular case there is a level of representation we say that's appropriate for the severity of the type of case, and that could be in any number of tiers and not just in the High Court tier or wherever. So all we're saying is that you need to look, if we're stuck in this route, we need to be looking at the level of representation in a holistic view and not in this blunt instrument view of saying that's that tier and you're going to get one solicitor and no one else is ever going to come into this case, no matter about the gravity of or complexity of the issues. We're saying that's wrong, and that sort of inflexibility when brought into this will create more problems, because ultimately you'll end up with appeals, you'll end up with decisions incorrectly made. So we say but defining it by tier is not the way to do it. You have to look at the severity of what's going on and define that correctly before you just say in X tier you get X lawyer.
Mr. Wells.
We've been here before, gentlemen, haven't we? Now let's look at the real facts. The only thing is any consolation with the group that's perhaps more unpopular than yourselves or us MLAs. Let's look at 2.3 in the department's paper. The legal aid costs for children's order cases across all court tiers has increased from £8.5 million in 0708 to £23 million in 1112. That's almost a trebling in 4 years.
Yes.
Now, surely the Minister's absolutely right to address this as a steam train that's running out of control. We simply cannot tolerate that increase in expenditure in this field in a time of economic recession.
That's predicated on the assumption that you're just writing the cheques all the time to the lawyers. You're writing the cheques for the cases that come into the system. We hear that argument all the time, and it's a well-made argument. I read that article and that argument in the press all the time. But the point is that the money that's being spent by the Department of Justice is money that's being spent on a justice system to deal with the number of cases in the system. I've already indicated in my presentation that the number of cases is increasing year in, year out, and in a demand-led system where the fees haven't altered since 1996, and when the fees are and the number of cases is increasing, of course you will get an increase in the budget. And the sad thing is you haven't, or no one has bothered to calculate what that budget is or ought to be.
Would we see the outcomes of this? Because thankfully, we now see some of the fees that your members are acquiring are accumulating in a given year.
Not in family cases, you're not...
No, we're seeing the overall solicitors' fees, and some of them are extremely high. Now, a quote from one example, without naming the lady, but the lady, the QC who got by last year on £892,000. Now, I think that's an adequate remuneration for that lady's work. Could she not provide first-class representation for a savage cut down to, say, £760,000?
Well, as President of the Law Society, I think I let the bar answer that question for you. I'm not answering that question for a member of the bar.
What about some solicitors then? What about one solicitor's firm who's got over £2 million in legal aid?
I accept that you see that figure. That figure's put to me all the time. You tell me what it was for.
Well, what I'm saying is companies like Kevin Winters and Matthew Finucane are doing very well.
Kevin Winters and Matthew Finucane employ significant numbers of staff. He does significant numbers of cases, and you throw a number at me, but you don't tell me what it is. There is no drilling into what that figure is, how much work is done, how many hours are spent on it, how many files it is. It is just a number. You don't tell me how many years the fee was incurred over. You give me a figure. Some of these cases run for 3, 4, 5, 6, 7 years, and then cumulatively the fees land in a final year. Now, I'm not here to represent Mr. That's for other solicitors to say that. But what I'm saying is, you throw that figure, but you're not telling me what it's for. It's a great headline.
Yes, it is. But I'll tell you, what I'm saying is that I have no doubt that folk work very hard for that. But if I was a QC, would feel equally motivated to provide first-class representation for $750,000 a year rather than $900,000. And if it's a solicitor's company, I'd be quite happy to provide fantastic representation for a lot less than $2 million.
Well, I won't answer for the QC. I will answer for the solicitor, and I'll tell you what the answer for the solicitor is this. The QC can come up and the bar can come up and give you their answer on the fees and the brief fees that they charge. As a solicitor, I charge an hourly rate. That rate, in any particular case, at the end of the case, is checked out The file has gone over. If it's a legally aided case, it's sent into the taxing office. The taxing master takes my file. He goes through that file. He applies an hourly rate to my file. He checks it against the work that I've done on my file. And then at the end of the day, he gives me, and this is a court-appointed and government-appointed officer, who then decides what I'm entitled to. I'm not, however, here to tell you how the bar calculate their fees. I think I leave it to them to do it. What I'm saying is that I have on my file measurable statistics which are checked by a court officer who calculates what I'm entitled to according to criteria set by law on an hourly rate set by law, and then pays. But I can't tell you how bar fees are worked.
Those are generous. Now, given the fact that we are in a recession and all other government agencies and departments are expected to make cutbacks, why should the members of the Bar Council be immune from that process? Why should you not take the same haircut that many other professionals have had to take in the present recession? Yet the reality is, even implementing Mr. Ford's so-called, as well, remember, sandwich cuts, the figures that we got for the year after that showed that, in fact, the take-home pay from many of your members had actually increased after the sandwich cuts implemented by Mr. Ford. Now, either you're working extremely even harder, or else the cuts are still not adequately reducing the costs.
Well, I'm not sure what figures you're giving, because you keep referring to me as the Bar Council, and I am the President of the Law Society, which is a representative and regulatory
your members
body
as well.
of the Solicitors Branch.
Your members as well.
So I'm not sure what those statistics are.
Chairman, if I may, I think just a couple of points to supplement what the President has already said. There is a huge distinction in terms of the practice of solicitors. What you're seeing published is the income from the legal aid fund for that firm. So you do not know, in fact, how many solicitors are involved, how many people that is covering, and more particularly, we have consistently asked for more detailed figures on a year-by-year basis to the number of people who are being helped. So in other words, what is that money actually buying? What we see is these figures being published year on year, but they're not actually showing value for money because they're not actually showing what is being purchased. And I'm concerned that there appears to be a misapprehension in terms of solicitors' firms, that it seems that because the firm is mentioned and the income against the firm, that's regarded as an income against one person's work. That's not. That's the entirety of the firm. And there could be any number of solicitors, any number of clients, any number of cases, as the President says, over any number of years. So I think just in terms of that particular issue, I wanted just to add that to the equation.
That's helpful. Well, I took part in a family division case quite recently. For some unknown reason, there were 3 counsel involved in the case, because I had frequently with my constituent, I had to go into chambers and have a briefing on it. Now, I would love to know what the junior counsel's role is, the second tier of representation. I watch these cases happening all the time, and I just do not see what the assistant, the junior counsel, is actually doing. But I do know this, that if it's under legal aid, a very big bill is coming to the taxpayer for that person's work. Well, and yet you're saying that there shouldn't be some control over the appointment.
No,
counsel.
Again, I say to you that as President of the Law Society of Northern Ireland and the representative body of the Solicitors Branch of the profession, I think maybe you should be asking that question of someone else. What we say in these cases this afternoon is that there should be, and it's important to understand what I'm saying, an appropriate level of representation appropriate to the case.
It's you that applies for the extra counsel. It's you that asks for it. The solicitor.
If it's considered appropriate to make the application, an application will be made. That application, give me one moment, is measured against statutory criteria. The judge hearing the case applies those criteria. He decides whether it's appropriate or not. We do not decide that. If he decides that there is no merit in the application, he will not grant the certificate. So there are criteria established for that, and we are saying today that it's quite correct, and you're quite right to question these things, that there should be appropriate representation in appropriate cases. We need to look at the definition of that very carefully. We take issue of the definition that's coming down, but we are saying, yes, there should entirely be appropriate representation in appropriate cases, and we're also just saying that when you define what that appropriate representation is, you shouldn't just say that in X court this is going to happen. We're saying that there should be clearly established clearly understood criteria for application by the judge to that. But yes, those are judge-appointed counsel. They're not appointed by the...
I think we just need to actually clarify the position. I think where the President is referring to certainly is the level of counsel is granted by the judiciary in criminal cases. In respect of civil cases, that is a matter of looking at what currently is provided for by statute. There's an inherent grant under the legal aid legislation in respect of civil cases of a certain tier where you will get one junior counsel, and it's been recommended that will go. But those applications on the civil side, that's what we're talking about here today, are actually made to the Legal Services Commission. And it's the Commission then that decide on the basis of the application which the solicitor makes as to whether or not it's appropriate that a junior counsel or a senior counsel should be granted, subject to the fact that there are certain provisions where there's an inherent grant under the 1965 legislation where you will automatically get a junior counsel.
Yes, but I don't understand why you would be pushing to have junior counsel or dual counsel. I don't actually know what the second person does. Would someone tell me? Because I'm sitting there in court all the time and I'm watching it, and I don't see a lot of activity from the second person in the chamber. What are they doing, and why are they appointed? Because that's leading to £4.8 million a year. Why are we going down this road?
You're dealing with a case with maybe 20 lever arch files of discoverable material from, and this is my area of court work, is all to do with children. So these are contact notes, these are reports and all sorts of materials about what social services interaction with this family was over a period. Somebody needs to trawl through all those and pick out the bits that you need that focus on points you want to try and use that would assist your client to continue to parent their child, or which might be able to say, well look, there's work could be done with this person to help them better look after their child and prevent things happening, and hopefully the child will be restored. All that work has to be done by somebody. That is what a junior counsel, they'll go through all the discoverable material, they will draft documentation that relate to it. So if the case gets really big, I wouldn't have the time to do that. So junior counsel would be doing that while senior counsel is organising the whole overview of the case and getting the law sorted out. So that's...
Well, I've been involved in quite a few of these cases. I'm glad to say that personally, thank goodness. But what I have seen is some incredibly acrimonious cases that go on and on and on, where basically there's absolutely no love lost between the various parties. And under the present system, there is no incentive for your members or the Bar Council members to try and get conciliation and get that closed, because obviously the fees continue.
With the greatest respect, surely the problem is those things should never be allowed to come to court in the first place. The system needs to be different. I deal with these people coming in matrimonial and divorce cases all the time. First thing I say is, don't expect me to go out there and fight every corner about everything. I'm going to tell you what's fair. This is any objective person looking at your case says it's perfectly okay for you to see your kid on a Saturday at whatever. If that doesn't suit because he's actually working, well, do you know what? Think of another time. There's a lot of stuff that is allowed to just grow and grow and grow, and the current system lets people who can get legal aid fight their way endlessly.
Ms. Dixon, I'm not far from convinced that all of the legal profession take the same stance as you, because the present system encourages cases to run and run and run and not to move to reconciliation.
That's what I'm saying. In relation to private law cases, it does, and we should not enable somebody who's on legal aid to be able to run a case forever when somebody who was a millionaire wouldn't dream of doing it. So that is the system. That's for you as the legislators to do something about the system. We can only work the system that's there.
But often one of the reasons that fuels that is that one party's on legal aid and the other isn't. And the party who's at the throat of the other knows that they can basically starve out
yes,
the
long pocket.
By letting it run. Now the problem is, I see a lot of solicitors and a lot of barristers extremely happy with that, because they're not desperately trying to get the case to reconciliation. It'll run for years.
Well, I can only say that is not what I do, and not what most experienced solicitors who do this sort of work do, because actually we've got lots of people who would actually need really important things sorted out. We want those things dealt with quickly. We live in the community. We meet the people in the supermarket. We do not want to have wrong running. We want things sorted for people properly in the community. That's the benefit of being a solicitor. You actually meet all your people and wherever you can't hide from them.
Final point is, even taking the worst case scenario that you're suggesting here, and even taking out these savings, your members will still be getting a very, very sizable income to carry on the work that you're doing in family division. Now, you may have to do it for 20% less, but it'll still be a very attractive income in the present recession. So therefore, why can you not simply accept you will do the same, you'll deliver the same service, but for less?
I thought this wasn't about fees at all. We were here to talk about levels of representation.
Well,
if you want to have this fight, we can have it some other day.
Well, that then leads to the increase in the costs that are going rampant.
The costs...
I mean, with respect, we are here to talk about the protection of children in the justice system in this jurisdiction. And we're here to talk about the representation that those children need in order to achieve the best solution and the best outcome for that child and for that family, which is the duty of law imposed under the UN Convention and in the Children Order. And that is what we are here today to talk about. Our concern principally is this. In the consultation document promoted and promulgated by the Department, what we see in the conclusion, and I think this has already been referred to by one of the members, is that this clearly is a cost-cutting exercise. That is the objective. Now, that may be a laudable objective, it may be a suitable objective, that is for other people to determine. However, what is entirely missing is the kind of information I've already referred to, which seems to be missing in the system generally. And what is entirely missing, and we've heard a lot this afternoon before this committee about the need, which is entirely right and entirely appropriate, to operate on an evidence-based policy-making platform. My question for the Department is, where is the evidence of what the cost drivers actually are? It's quite clear to practitioners, and it's quite clear from the court statistics, there is an increase in court business. There is an increase in the complexity of the issues coming before the court. We're even now, and we've been working with your previous witnesses in terms of identifying new and different issues in terms perhaps of behavioural issues, actually are communication issues. So we are constantly learning from other experiences. There are new areas of law being developed. There are new expertises which need to be taken into account. Where in the Department's proposals is there any analysis of what the cost drivers actually are and what the impact of cutting back in this way in terms of representation is going to have on the individual child in this community and in this jurisdiction? And just by way of example, I think, and I hope I'm right in saying this, and colleagues and you also will keep me right if I'm not, but I think there was a substantial change following the BBP and other cases, when it was decided as a matter of social policy that there required to be more direct supervision, more direct intervention, and there required to be more cases brought before the court for supervision and resolution. That inevitably is going to lead to an increase in the legal aid. And yet again can I sit before this committee, and yet again can I call on the Department, when there are these changes identified throughout government on a joined up approach, can there be some joined up thinking in terms of the cost to the legal aid bill when these matters actually reach court? Now, I don't see anything, and I haven't seen anything in terms of what those cost drivers are, and nor do I see anything about what the Department want to do other than cut fees, cut fees, cut fees. There will inevitably be an implication for the client at the end of the day when they want to go to see their local solicitor, and that solicitor is there.
Right. The point that was being made from the Department was, take out the barristers, the solicitors have the capacity to do this work. So what I want to know from yourselves is there the capacity within all of the different solicitors' practices across the province to actually do this work? The fees we will be coming back to at a future point, but in terms of that key point, can solicitors do the work that barristers currently are doing?
I think there are a range, clearly, of capabilities within the profession. I think, as Catherine has said earlier, figures show that the vast majority of these cases, 92% of these cases, are dealt with at family proceedings court level, which is at the lowest tier. And I think it's only 18% of the cases, those cases on the figures which the department show, have counsel involved at all. So the vast majority of that work has been done in the family proceedings court. There's a much smaller number, I think it's 5 and 2%. Clearly the 8% that's left are dealt with the higher tiers. At present, there are a number of solicitors who will undertake that advocacy work in the family care centre. I think it is a brave solicitor who at this point in time will undertake work in the High Court. And part of that is to do with, say, the lack of opportunity that they've had to do that, because the current legal aid arrangements make no provision to pay them for doing that. So in fact, when Catherine has done work in the family care centre on her own, without where in fact she would be entitled to instruct a junior counsel, she gets no extra payment for that. So inevitably, I think, Chair, the answer to your question ties in with the provision of a fee to remunerate solicitors for actually doing that work. In fact, the department, in their response, make reference to that's an issue which they're looking at. Broader consultations and discussions that are going on about increased rights of audience, which will come before the committee, I'm sure, at some stage later in the year. So.
Okay.
But the answer to, just to interrupt you again, the answer to that is, but in some cases you just need to.
Yes.
Because like the doctor looking into the heart surgeon looking into the open wound, you wouldn't want the heart surgeon standing there on his own. In some cases they're so extremely complex factually, so extremely complex legally, and so extremely complex in terms of the volume of documentation. In some cases you just actually need to have more than one lawyer, be that a solicitor with another solicitor advocate, or soon changes in legislation, or with junior counsel, or whatever you call them. In some cases you just need that. And we're not saying at all, to be absolutely clear, that that is justified in all cases. We're saying that in appropriate cases, with appropriate definition of when that should apply, in appropriate cases, just sometimes you can't do it with one lawyer. You need two, like you need a heart surgeon and an anaesthetist and someone else around the bed, and that's all that happens. We're not at all saying that in all tiers you need a solicitor, and as Peter rightly pointed out, the massive number of cases are dealt with by solicitors on their own. It's a very, very, very small percentage where there are two lawyers, and an even smaller percentage where there are three lawyers. And we're not saying that those are all right. We're saying that we need to look at that, but we need to get the definition of how we decide when there's more than one lawyer absolutely right, so that the injustices don't take place. But we're not at all arguing with the thesis of it at all. We're saying that we should be looking at that, we should be clarifying that, and we accept that. We also say, though, that it's nitpicking and cherry picking when there should be a more holistic approach, because you've heard from one of our members today who said it's not good enough. It's not good enough just to look for cost savings in the lawyers' fees that haven't increased since 1996. It's just not good enough. There are other things in the system that need to be looked at to protect these vulnerable people. And it's always the headlines. We're getting the headlines with you today. I read them every Sunday morning in the newspapers. And I'm sure Kevin Winters is absolutely fed up reading about his lawyers, many of whom he employs many, and of significant amounts of money he puts into the community. I'm sure they're fed up looking at it, because the reality of it is there's significant and good work being done, but no one takes a holistic approach of everything else. They look at the lawyers' fees. That's where it all is. It's the level of representation. You're talking about 2 or 3% of these cases. Yeah, that's what you're talking about today. 2 or 3% of the cases. We're saying there's no holistic approach taken of that, and that's the nitpicking. Everybody jumps in the headline, but there's bigger issues in the system. Catherine, who's experienced in that system, is saying it loudly and clearly. There's no holistic approach being taken to it at all.
We'll resist going back to that.
Okay.
Please.
Trying to move us away from that.
Fine.
And there probably won't be a headline at 7 o'clock at night, in fairness.
I'm sure it won't.
Someone will trawl through Hansard maybe tomorrow. Mr McGuinness.
Thank you very much. Chair, I'm going to have to go in about 5 minutes.
Is she even interested to declare, Mr McGuinness? Big interest to declare.
School beckons. But could I say thank you very much for coming, because I do think you've clarified the position in relation to representation. But look, this is putting the cart before the horse. This is a cost-saving exercise, nothing to do with, refining representation and all the rest. Now, the very simple thing to do here, and that is you could repeal the Children's Order. That's a very simple thing to do. But what are the social consequences of that? And the fact is, this is a demand-led in terms of, I would say, the deterioration in given relationships in society and so forth, and we have to address it. And you have to try and pick up the pieces and put them together. But a couple of points I would just ask you. We know by the Magistrates' Court, mostly solicitors there, very few barristers, so there's not going to be a saving there. Is that agreed?
Can't see it being a big saving, that's for
It wouldn't be a big saving. In the county court, the Family Care Centre, a number of junior barristers involved there. Would there be a big saving in terms of excluding senior counsel from there?
We don't have the figures, but certainly on the
Ms Dixon might know in terms of her experience in that.
And I have rarely seen senior counsel in the Family Care Centre, but then I'm down in Craigavon, so that's so far away from the rest of the world.
Yes.
Maybe they don't make it down.
But in terms of actually getting a saving by excluding senior counsel from the Family Care Centre, would there be, in your estimation?
I can't see that it could be that large, because I don't think
so there wouldn't be a significant saving.
No matter what we extrapolate it out, it doesn't look, we don't actually have the figures, but it doesn't look like very many, that's for sure.
Yeah, and then in relation to the High Court, you would require at least senior counsel, if not a junior counsel in the High Court in a number of cases.
I would only employ junior counsel, because I can work with them as a team, the two of us.
Okay.
Not all my colleagues could, and bearing in mind the nature of the cases that I am doing, so there are certainly in a case with different parties, some parties require a different level of representation because of the nature of their case.
I recall the evidence of Miss Keegan, and I think she talked in terms of QC who gave evidence to this kind of, I think she talked in terms of 44% of cases in the High Court had senior counsel. Yes,
it would be less than half of the cases that are in the High Court, and of those, the cases that are in the High Court are only between 4 and 5% of the totality of all the child protection cases.
So you'd be, if there was to be a reform, you would exclude half of, you would exclude senior counsel from half of those cases, roughly, in the High Court.
There's 44% of senior counsel in the High Court.
Yes.
Those are the figures that were provided by the bar.
Yes.
And that's only 4 or 5% of the totality of the cases in the system.
Yes.
And by their very nature, they're in the High Court because they're pretty serious.
Yes.
I mean, that's the whole point. The High Court is where the High Court are quite happy to push cases down again. If a case comes up and they don't think it's serious enough, they'll push it down.
So can I ask, the last question really is, where is the savings going to be gotten in terms of the reduction in representation?
Well, I don't know. The legal services have obviously, or maybe the department have done these figures. We don't know. They've obviously worked out how many barristers.
On the figures, 44%. On the figures in the High Court, it's only 4 to 5% of all of the cases that ever get near the High Court. Of those, 44% have senior counsel in them. So it's something less than 2% of all cases, all of the cases overall, might have senior counsel in the High Court. Now, as Catherine said, they're in the High Court for some reason, and we say that there should be appropriate representation in appropriate cases. You're not going to shed all the senior counsel in the High Court. You can't possibly do that. There's a reason why the cases are there. So even if you were shaving off some of that, what's the real saving? That's for the department to extrapolate, but that's the sort of argument that's taking place with regard to levels of representation. So the significant majority of these cases are dealt with by our member solicitors in the community in the Court of First Tier. Something like 90% of these cases are dealt with by one solicitor in the First Tier.
Just the final question, and that is, if you abolished counsel, removed counsel from all of these children's cases, High Court, County Court, leave the Magistrates Court out of it, I mean, would solicitors really be able to do the cases?
Not the High Court cases.
Not the High Court.
I mean, I have to say there is no way, even somebody like me who's quite passionate on the subject, I could not run a High Court care case on my own in the High Court. Just the sheer volume of the materials, the law to check and everything. Because I'm also running a small business. I have staff. I have to see the clients across the door. So all those things are just not conducive to going away and doing lots of legal research.
Well, but Mr. McGuinness, I think what Catherine's actually saying is that as counsel in the High Court isn't running a case on his own, Catherine in the High Court won't be running a case on her own. So when you get into the High Court, the sheer complexity of it means that no lawyer is running the case on their own in the High Court, and you know that, having been a practicing barrister. So that's really what she's saying. What we're saying is that there should be appropriate representation in appropriate cases at appropriate levels of the court system, that level of representation being decided by appropriate criteria. We're saying that the blunt instrument of just stripping it out is the wrong thing to do, and that you need to measure it, and you need to be more measured than just saying, well, it's just not going to happen in a certain court tier, because the complexity of the issues is such that there must be a more discretionary approach to it. And that's what we're saying in relation to the consultation document, which is a lot more blunt than that. We're saying it's far too blunt, apart from the fact it just doesn't take into account the other holistic issues that we suggest it should take into account.
And we have suggested all sorts of things along the way, various practitioners, but somehow there are all sorts of things in the system that are mad, like legal aid. You want to see the bureaucracy in legal aid. You have never seen bureaucracy like it till you start doing legal aid forms. It would do your head in. And I on occasions I have had, because there's been 5 children in a family, I have had to fill in 3 sets of forms for each of the 5 children. So I fill in one, and my secretary has to go filling in the others. Then we check them all, and then put some poor soul up on legal aid has to then look at those 15 forms, and if there's one mistake in them, they come back. So, I mean, that sort of wastage is unbelievable.
That's another debate.
It is. But the benefit of getting the legal aid, as Catherine would say, is significant to those children in need.
Yes.
Can I just say to my own members here, Mr. McGuinness needs to leave, and I know Mr. Dixon needs to leave as well. At that point, I'm only left with 5, and there's another item that we need to sign off a report on, which there's no...
Okay, that's
so long as...
They're also about to set a record. I don't know.
Law Society, we haven't finished yet.
I'm sorry, Chair, I really do have to go.
Wait, earn somebody in the courts.
Mr. McCartney.
Okay, thank you very much. When Michael gave the scenario of the heart surgeon and the anaesthetist guys said it's the time they panic is when you see the QC leaning over both their shoulders. Well, you really know you're in trouble.
Mr. McCartney, as I said, the bar has to answer. You keep asking me about the bar and I can't answer, you know.
But, I mean, in fairness, the presentations they did have been around the levels of representation. Now, there's no doubt fees impact, and there's no point saying that it doesn't. And I think the principle of, and I think a couple of times in your opening remarks you used the phrase the appropriate level of representation, and I think that's what we have to nail down and drill down and get. Now, when the officials were here, the question was asked if there were no issues around financing these cases, would they still be proposing the flexibility and the change of representation? Now, I suppose they said yes, and they would say that anyway, but it's trying to find out right now One of the things, and we discussed this when the representatives of the bar were here, and that's that sort of, and it can be the headline, and we know that people do deal in headlines, but to know it sometimes when people write letters to people, they talk about all politicians, right? You know, and it's not every politician that says or does the same thing. But it's this sort of thing of over-representation. And there's a scenario painted by the officials of maybe, you know, down to the granny. And that's not to say in certain circumstances grandmothers can be, need to be represented, but it gives that sort of feeling. Every case that goes in front of the court, there's a glut of legal representatives, so you can nearly make up someone who needs to be represented so you can get someone in the room. It's how, first of all, you dispel that, and then secondly, how you say, well, we're absolutely sure, and there's a...
I am very confident that is not the case, because first of all, the only people who can be represented in court under the Children Order are those with parental responsibility. So those have to be mum and dad, don't have to be married, but they have to be mum and dad. If Granny wants to be represented, she has to actually make a leave application to the judge. So I have been in court where Granny's been told, not today, love, we'll look at it in a while, we'll decide are you actually relevant. The fact that you care about your grandchildren's good, we want to know that, but we're not necessarily making you a party just because you want to come in here. So I have actually seen Granny sent away and who have come back a number of times. Their legal team are not being paid for coming to do those leave applications. So they're coming along trying to get her in as a party and being turned away. In other instances, I've actually had judges direct, I want those grandparents brought here because I want them to understand they're in the frame that possibly they committed a non-accidental injury to this child, so I want them to be here to hear what's going to be said. So the judges actually control the numbers of parties, and it is, in my experience, the multiplicity of parties is not a case, and I'd be very interested if the Department or the Legal Services Commission could produce that, because I don't think you'll find that we're talking about a lot of cases at all.
And one of the other scenarios they talked about, you know, is that, and they were given the impression, I mean, may be wrong, but I'll give it as I seen it, right, was, you know, you can see a situation where it's appropriate, say, for a senior counsel to come in. Right, but it might be for a day on a particular point of law or a level of competence. They were given this impression, I don't want to be unfair, but it was nearly as if once they're in the door, that's them there until it ends. Where they were arguing that if a QC is required, then it should only be for the period for which they're required. So that's, you know, to me, it's a good definition of appropriate level. If you need a QC for 2 days, then once they're finished, you leave. They were given this sort of suggestion that once you say you need a QC and you get it, that they're there until the case ends. Is that...
The problem is, the structure is, there is no option to bring them in to do one piece of work. They're in or they're not in. Now, there are times, if you were a private client and you come along about something, I may say, do you know, that's really difficult wee bit of law here, let's get an opinion and we can go and get it. The legal aid don't seem to be able to create the structures that you can go along and say, we just need this wee bit of help, or I need this, there's say a new Supreme Court decision and we think it impacts, let's get an opinion on that. We don't necessarily need to bring somebody in for the whole duration of the case. There isn't that flexibility in the system doesn't allow us to do that.
In fact, in our own response, Mr McCartney, we'd said that the Department may wish to consider whether there should be an option for the application for the use of senior counsel for various purposes, in fact even short of conducting the hearing of the case, which in fact is even before the scenario you mentioned, such as obtaining an opinion or facilitating a whole consultation that bring heads together or whatever. So I think, as Catherine says, without apologising for the Legal Service Commission, I think the existing legislation doesn't allow them to actually engineer the grants of their certificates to facilitate that, but it is something that we've already recommended to them that they might want to think about.
Well, I mean, in fairness to the official, I know in a quote they say, the flexibility we propose allows for representation to come in at a later stage or to be increased, or indeed a bar to come in a particular piece of proceedings for a limited legal aid certificate. So I mean, in many ways you don't see that undermining your ability to present the case. Obviously.
No, absolutely. No, it's the appropriate level and appropriate work at appropriate stages.
Yeah. Okay, that's lovely. Thank you. Mr. Lynch.
Just finally, thanks, Chair. Michael, I think you mentioned about 40%, if I heard you right.
Yes, in the High Court
cases.
Yes.
What's given rise to such significant rise? What was the causes of such a significant rise?
You're talking about the overall increase generally, because we are seeing it as an organisation a continuing increase in these cases. And I have to say, regretfully, in the answer to your colleague's question earlier on, that will filter through the system somewhere else. And we're not sure that the legal aid budget has actually said to us, now what do you see coming through the system? Because you'll be sitting here in a year's time and there'll be another X thousand cases in the system. They'll have worked their way through the system, and suddenly someone's going to turn around and say, oh, where did they come from? We're telling you that any reasonable assessment of what's in the system should be able to extrapolate out and tell you what the future potential risk and cost is. As good businessmen in the community, we do that good governance in our office on a day-to-day basis. We make an assessment. We make an assessment for insurance companies and other clients. It's not being done. And the question that you're asking is, there will be, and Catherine sees in the system, an increase in the number of these cases. And you'll be sitting next year with statistics telling you that there's been an increase in suddenly in legal aid when it hasn't been. It's these working through the system, and that's our great concern, that holistic view of where we are is not taken. There's a budget set, and then suddenly these cases are coming and no one's even thinking about what's in the system.
The Department of Health would be able to tell you. I mean, there's statistics. I used to sit on the Lord Chancellor's Advisory Committee, and we get statistics which is showing what's coming into the system, cases coming into the system. The Department of Health and Public and whatever, they also sit on that committee, and they're able to say, oh yes, we can see what's coming through in terms of child protection through social workers. So this is all the information is there. Nobody's actually putting it together and saying, what are we going to do? Because this is just getting bigger and bigger.
The point Mr. Hunter made earlier, which is, there are clearly at times changes in policy. There was a huge change after the BBC case. We had the Hill case here as well in Northern Ireland, where where social work teams may have looked at something in a certain way, and then because of something dramatic which happens, then all of those procedures have to be reviewed, and that all clearly has knock-on effects. That is going to lead to trusts and whatever changing their policies and bringing more children, certainly starting proceedings and possibly bringing more children to bear.
Would the increase of sexual abuse cases be given rise to that?
Sex abuse isn't actually, in child protection, probably the biggest area is neglect. Now, whether it's intentional neglect by the parents or deliberate neglect is, so the biggest portion is neglect. Yes, abuses of various kinds, both physical and I suppose you can regard neglect as a form of abuse. And then, yes, there's sex abuse, but sex abuse wouldn't actually be, it's the rarer thing and would generally end up in the High Court.
And finally, what's your view of the Commission will have discretion? What are exceptional cases?
Well, that's what we'd like to know, this word norm. I'd love to know what that meant, because they're saying in the Department's post-consultation report that it's whatever the norm is, and the case has to be beyond the norm, but what is the norm? Yeah. Because even Access to Justice and all the reports they've ever looked at this say these cases are peculiar unto themselves. No, we all know when you shut your front door, what goes on in your house is peculiar to your house, and even as a child visiting other people's houses, you knew your houses were different than yours, so you can't really sandwich it as tightly as that, but we've got to have boundaries. I understand that, but they've got to be flexible enough to enable us to assess as a solicitor looking at a case, do I need help or do I not? And also, I mean, there's a whole area we're not going into now about experts and the cost of experts and whether the courts should legal aid be funding those experts? Should health be funding those experts? Is there a different way in which we could go about this? Could the experts be brought in some global way and not have separate experts or not have a multiplicity of experts if we could narrow the issues down? I mean, there's a lot in this where there's money that could be saved, and experts are a big cost in the family system.
All right, if there's nobody else, so thank you very much.
Chairman, thanks very much for the opportunity to come today and talk.
Jill.
appreciate
I
it.
thought some members might at this stage of proceedings have been, more relaxed and not as
Well,
but it shows
it's an investigatory committee, and we're delighted to come and talk. And at any time, we are delighted to come and talk to you because it's very important. These issues are significant in the community, and as an organisation, we are delighted to engage on them.
All right. Well, we appreciate you making yourselves available.
Thank you very much indeed.
Thank you.
Legal fee.
Okay, members, so we've got the Bar Council session that we had with the committee, and now we've obviously the Law Society. So if we send both sessions to the department, they're coming on the 3rd of October to talk about this area, and we'll ask them to give us a written response in advance of that. It'll help us inform the line of questioning we'll take with the department when they come before us. So if members are happy, we'll do that. Right, item 8.
Get into the middle meeting now. We're getting into the main bit. I think we've just broken the record. Sure, this is the longest meeting ever. I think it is the longest ever held at Stormont.
And there's no overtime rate for us. So we'll keep going.